Hello, everybody. Thank you for joining. Ashpata, would you be able to switch on your camera so that we can just do a quick tech check? Also, we have already started streaming on, on YouTube. I was just checking. I didn't think it'll actually go live, but it's okay, I guess.
Can I also try sharing my screen?
Yeah. Okay, you can share your screen. Great. Okay, looks great. Hi, Mukta. This is Disha. Thank you so much for joining. Before, I think we'll just wait 2 more minutes for more people to join in. We had like 142 like registrations.
Oh, wow.
So we're just gonna give it another 5 minutes. But can you say something? We just wanted to check audio.
Yeah, sure. Can you hear me?
Yeah, that's perfect. Also, we're live on YouTube.
Yeah.
A little too soon because I didn't know it would actually go live. I think we can get started. I hope more people join because we had a lot of signups. We had like 3x the signups, but I think we can get started. Thank you both of you. Thank you for joining. I'll start off with introducing you both, and then we can start. Sorry, just give me a second. Okay, we can start. Mukta, were you trying to say something? You are on mute. Oh, okay, sorry. I think you should be able to unmute now.
Yeah, I was asking if this meeting is being recorded.
Yes, it is being recorded. It's also being live streamed on YouTube. Yeah, it already started, unfortunately, because I didn't realize when I pressed that button, it'll like start immediately. But yeah. Okay, so we can get started. Thank you everyone for joining us today. This is a discussion on the history implications and dilutions implications of the Forest Conservation Act, as well as the Forest Rights Act. The dilutions, although have been recent, this has been something that has been happening for the past few years, and it hasn't always gotten the attention from the mainstream media or even from people as much as it is getting at the moment. But it does have, because of its complicated past, a lot of people do have a hard time understanding it, and it's also covered in a lot of jargon, which makes it inaccessible to a lot of people. Which is why we at Fridays for Future India, along with Yugma Network and other climate and environmental movements, are organizing a series of interactive webinars with experts to understand the dilutions and implications of these policies. Like I mentioned, today we'll be covering the Forest Conservation Act of 1980 and the Forest Rights Act of 2006. And today we're joined by Arpita and Mukta. Arpita Kodiveri is a professor of clinical law at NYU Law and research director at the Center for Human Rights and Global Justice. She received a doctoral degree in law from European University Institute as a Hans Kelsen Fellow. Her research examines land conflicts and legal mobilization by forest-dwelling communities in India. She has previously practiced as an environmental lawyer in India, supporting forest-dwelling communities. She has an LLM from UC Berkeley as a Fulbright Nehru Fellow and a BSL LLB from ILS College, Pune. And Mukta J is a lawyer working with Land Conflict Watch, which is a network of researchers studying law, forest and environmental governance in India. Thank you both for joining us. And I will hand it off to both of you. Mukta, I believe you wanted to start, so you can start.
I thought Arpita was starting.
Okay, sorry.
That's okay. In a way, I have the easier task. Mukta has the harder one. So what I'll be doing is sort of giving you a brief overview of the Forest Rights Act and the Forest Conservation Act, and give you some clues of how they can be read together or how do they conflict with each other. What really is the mechanics of that? And before I dive into that, I also just wanted to thank Fridays for the Future and Yugma Network for putting this together, and Mukta for being here too. So I'm going to share my screen. I think, Disha, you need to give me the powers to do that.
Yeah, sorry, I just enable some security protocols, and unfortunately, for some reason, it won't let me make anyone else host. So that's an issue. But yeah, you must be able to share it now.
Yes, I can. Okay. So it's actually a pretty tall task to be able to give you a very concise view of the Forest Conservation Act and the Forest Rights Act, but I'm going to try my best. And in trying to kind of narrate the stories of these laws, what I'm going to do is sort of look at what is the legal intent, what was the purpose of these laws, what kind of legal issue are they trying to solve. I then want to go in a bit into like how do they get implemented and how they operationalize. And then I'll spend a bit of time talking about how they interact. It's more of a descriptive presentation. I'll try and sort of couch it in some of the political analysis as I go along. If at any time something stands out as confusing or inaccessible, just stop me. And I apologize in advance for the lot of Tintin references. I know it's a colonial construct, but I'm a huge fan. Okay, now, what is the purpose and intent of each of these laws, right? So when the Forest Conservation Act came into being in 1980, it came at a time when states were basically deciding whether forests can be deforested or not. And there was a sudden sort of alarming fear that our forests were being completely depleted. So we need to centralize and decide that the center is going to make these decisions and prevent the states from having this discretionary power or just this ability to decide. So what you then had was a law that came into being, which essentially wanted to control deforestation. And that's its primary purpose, right? And the way it does that is it sort of not only centralizes decision making to the Ministry of Environment and Forests, what it also does is it creates an advisory committee, which kind of includes both members from the government, but also external experts sort of provide what one can say is sort of independent inputs into that decision-making process. And it was a very sort of basic act. Unlike other laws, it's just like a 3-page act or a 4-page act. I urge you to read it. And one of the tricky things it also does is it defines something called as non-forest purpose, right? What it says is you can deforest, but you need permission. It's not that it's a blanket ban on deforestation. The mechanism of it is that you can deforest, especially if you're going to do it for a non-forest purpose, and that definition has been quite contentious. What you need to do is get a forest clearance, and there are different steps in that process. And the rules sort of detail that. And I think Mukta will take you through that a lot more than I will. So you had this kind of architecture, and this also operates in the backdrop of like a thicket of laws. I think as a lawyer, I find forests to be the most heavily regulated spaces and geographies. And you also have what is the Indian Forest Act and the Wildlife Protection Act simultaneously operating on this particular unit of land or forest, right? And those laws, and the reason I think that background is important for you to understand where the Forest Rights Act fits into that thicket, is the Indian Forest Act gave a lot of wide discretionary power to the Forest Department and the Ministry of Environment and Forest to categorize forests. And by categorizing, what it also did was it decided whose rights can be exercised in these spaces and whose cannot. So a lot of this kind of history of forest laws has always marginalized forest dwelling communities. So there's always been a sort of, it's not just a tension, but there's been a political reality of exclusion of forest dwelling communities. And there's been a struggle to be able to push back through the law. And interestingly and very courageously, the Forest Rights Act of 2006 came into being. And what it did was it wanted to correct that historical injustice. I've sort of just copy pasted the purpose sort of from the preamble of the act. I urge you to sort of always read that when you're reading a law, because it gives you an insight into where it's coming from. And so what the Forest Rights Act did, interestingly, is it corrected historical injustice and this is a very sort of flattened way of narrating it, but it's easy and it makes the law accessible, so I'm doing it. One is it created mechanisms for communities to become part of conservation decision making, which they had been excluded from based on the Wildlife Protection Act. And the Gram Sabha became that primary node for a lot of that decision making. The second thing it also did is it provided Adivasi and forest dwelling communities rights over forest land. So one would call it security of tenure, in the sense that you don't own the land, but you have security of not being evicted from that piece of land, and you have the rights to exercise livelihood, right? Because a lot of these communities, their livelihood is dependent on these forest resources. And the third thing it did was it also allowed sort of an extension of the livelihood aspect. Is it allowed communities, I know allowed is sort of a pejorative sort of way of saying it, but that's how the law articulates it, allowed them to use these resources, certain kinds of non-timber forest produce, to be able to earn a living. So it was kind of more of a social justice framework that was infused into forest law frameworks, which were fairly bureaucratic, fairly controlled by the forest department. And in some ways, the larger argument to be made is the Forest Rights Act in some ways came in at a time when a lot of these issues, like the eviction of forest dwelling communities, was kind of at its peak. And there's this whole story of the Godavarman judgment that I'm not going to get into because it will confuse you. But just keep in mind that a sort of a double register in your mind when you're looking at these laws, where you have an entire set of laws seeking to conserve forests and finding sort of slightly authoritarian and exclusionary ways of doing it. And then you have the Forest Rights Act, which provides another solution to that problem by saying that communities have to be active participants and have complete agency in decision making. So those are the kind of lenses that you can use. There's also a picture of Haddock here who says, "Here is a tropical forest, unbelievable." And the reason that's there is because the definition of forest is a whole other set of legal quagmire questions, which again, I don't want to confuse you with, but you can come back to it in the Q&A. So before I kind of go into the interaction, like I said, I wanted to quickly take you through how it's operationalized, right? So essentially, like I said, that it's a very permissive process that you can deforest, but you have to go through the forest clearance process. And the way it functions is it's a two-stage process. So I know Mukta is going to take you through more of the technicalities of it, but I just want to kind of alert you to how that process is kind of, so you have like a legal purpose, and then the realization is always a very bureaucratic and procedural articulation, which becomes kind of interesting when you look at a lot of forest governance. And within that, some of the aspects of that governance structure, which is kind of interesting, like I mentioned earlier, was the Forest Advisory Committee, but it can only advise. So its opinion needn't determine the state's decision, but it does provide a lot of inputs to arrive at that decision. And there is sort of teeth it has in terms of, if you look at the Niyamgiri case, where it was able to actually go back and reinvestigate the state's decision. So it's not like it's a very defunct body. I think it's had a tumultuous history, but there's some scope there for the coming together of the Forest Rights Act and the Forest Conservation Act to be able to determine the eventual outcome. The other interesting thing is because the judiciary has been so activist when it comes to the forest, to the extent where scholars like Sharat Chandra Lele and Rosencrantz argue that it's too much of an there's judicial overreach. It's taking on executive function, but it's interesting. Like you have a forest bench that meets, I think, once a week, and then it also created what they call a central empowered committee, where the judiciary also has the ability to review decisions of deforestation. So it's kind of like this decision to deforest sits in multiple pockets of that chain of decision making. And then you also have other clearances. So you have the environmental impact assessment process, and you also have a wildlife clearance process. So there are a lot of checks and balances in that sense within the existing environmental law framework. And the reason these aspects become important is because when you start to understand deregulation or dilution of environmental laws, you notice how this idea of a single window clearance becomes like a primary sort of vocabulary that they use, because it starts to collapse a lot of these avenues for checking state decision making into one window under the sort of energy of trying to be efficient and quick in decision making. But the question that we'll have to think of is how democratic is it? How feasible is it, given that we're sort of engulfed by the climate crisis, right? The last point is that communities, in terms of their ability to articulate their voice in this decision-making architecture, was very limited. So the only avenues, of course, communities are resilient and they've been protesting for years. There's already that they've sort of carved out for themselves, but the law necessarily didn't recognize that too much. It did it in bits and pieces. So within the EIA, there's the public hearing process. So sometimes communities would use that as the avenue to be able to, check state decision making again. Or the other was, if it was a scheduled area, there's another law called the Panchayat Extension of Scheduled Areas Act. And there the Gram Sabha has certain powers of decision making, where it can actually decide what the development plan looks like. But there's been a huge problem with implementing that law. So there's a tension. So there's a tension of like centralizing decision making, although the lives of those in the forests are being impacted. So there isn't decentralization enough till the Forest Rights Act came in. And even with the Forest Rights Act, there have been challenges in how that's kind of been realized. I don't want to go in too much here. I think I'm going to focus just on the Gram Sabha and free, prior, and informed consent. So like I said, I think one of the exercises you should do, especially if you're interested in this area, is just read the Forest Rights Act. And I think it's an important exercise, both in terms of understanding the law, but also in understanding how it decided to reverse some of these power dynamics of decision making in forest areas. So the Gram Sabha, in some ways, is seen as sort of the main governance node for a lot of decision making in the Forest Rights Act. And why is that important? Because if you look at the wave of dilutions of both the FCA and the FRA, particularly that consent provision, it's always been to try and limit the powers of the Gram Sabha. So then once you use the Gram Sabha as your window into understanding these dilutions, you'll be better equipped to see where things are going and what's happening. And why are they doing that, right? Obviously, because they want to continue to centralize the decision making and not have to, and to be able to do it quickly. So forest land can be made available for large infrastructure projects or mines. So it's an easier way to open up our forests. Whereas if you have to go through the Gram Sabha route and you have to, and Mukta will speak more to the consent provision, and obtain the consent of the Gram Sabha, it's more time consuming, but it's more just. So it's kind of like, how do you balance those priorities? I'm definitely not a fan of speedy environmental law. I don't think that's viable, but at the same time, there is this urgency in decision making for deforestation that a lot of these dilutions are trying to achieve. I just want to quickly sort of share an interesting nugget, because my thesis was actually on the consent provision for my doctoral studies. And I was trying to look at how come consent didn't come into the FRA landscape earlier. And the interesting history there was actually it did, but then it was removed. It was removed because there was a decision among the different ministries that PESA and existing laws would suffice, But then you again had a situation where in 2009, and especially because of the Niyamgiri struggle, that eventually this provision made its way into the law. So to say that it's not been easy for communities, right? It's been, all of these legal wins have been hardly fought, and it's kind of difficult to see how they're being diluted so easily. So there's also that aspect that I sort of wanted to highlight. I'll just quickly stop with this. Like, how do you then understand the interaction? I think these are sort of 5 ways in which you can do it. They're not definitely the most concrete ways of doing it, but I find it as an easy way to understand these 2 laws. One is the FCA is trying to prevent deforestation, as is the FRA, right? Both are trying to achieve conservation through different means. So just understanding how is the FCA trying to prevent deforestation and how is the FRA trying to do it, right? So the FRA has its own mechanism of consent and Gram Sabhas conserving these areas. And then you have the FCA, which is centralizing decision making. They meet at certain points, and the forest clearance is where that happens. So again, that's the consent and forest clearance part. The other way to think of it is sort of democratizing the deforestation decision, right? So how far do these forest dwelling communities have power in checking the state's decision to deforest, right? If the forest dwelling community, so one of the things I found during my thesis and the field work was Gram Sabha resolutions, which are the key sort of legally sort of a viable instrument to document their dissent in the forest clearance process, is seen as a cursory point of information. It's not seen as a legally determinative document. And so there's again there, like, how far is this going to influence the eventual decision? That's still up in the air. The other thing is, let's assume that there is a decision to deforest. I think what the Forest Rights Act provides is a certain way of being sort of a rights-based process for resettlement and rehabilitation, apart from the new land acquisition law. So there's a lot of, in some ways, there is enough security for these communities. Whether that gets implemented or not is a whole other thing. And the last thing is also the fact that if you read the Niyamgiri judgment closely, what it does is it recognizes the authority of the Gram Sabha. So again, where does the power exist in that decision-making architecture? So for you to be able to read this would be, okay, if like just take a single case, right? One way, interesting way to do it. Just assume that there's an iron ore mine opening up in an elephant corridor. This is quite a possible case. What you would then do is you would actually contrast what has the Gram Sabha decided about this in that particular area, what has the Forest Advisory Committee and the Ministry of Environment and Forest decided, if you have access to the forest clearance documents. And you'll start to see all these points of interaction. So my suggestion is, before you decide to provide comments for any of these dilutions, I think just go back and do a little bit of this homework. I'm happy to share these slides if they're useful, but I just want to stop there, I think. And I'm happy to take questions later. Over to you, Mukta.
Thanks for that, Arpita. You did a really great job of breaking down what exactly the difference between the Forest Conservation Act and the Forest Rights Act is. And like you said, the place where they intersect is the forest clearance process. Now, one key aspect of the forest clearance process is ensuring that forest rights have been settled and that the consent of the Gram Sabha has been obtained. Now, with this specific issue, there has been a lot of back and forth between the Environment Ministry and the Tribal Affairs Ministry, and there's a long and colorful history to how the current change in the rules has come about. So I thought a good place to start would just be to show you guys a timeline of the changes that have been made. Just a second. Yeah. So the Forest Conservation Act came into force in 1980, and the Forest Conservation Rules came into force in 2003. Now, at this stage, there was no question of ensuring forest rights were settled during the forest clearance process because the Forest Rights Act had not yet come into force. So in 2006, after the Forest Rights Act came into force, this requirement of ensuring that some sort of that forest dwellers had some sort of say in how the land was being used came into the picture. Now, in 2009, after the passing of the FRA, the Environment Ministry issued a circular laying down a very detailed process by which Gram Sabha consent had to be taken. And this included requirements such as certificate from the Gram Sabha ensuring that all the members of the Gram Sabha had understood the reasons for the diversion. The state government also had to certify that the proposals for the forest clearance were given in vernacular language, then that more than 50% of the Gram Sabha members were present at the time. So this was basically a mechanism to ensure that free, prior and informed consent was being taken before any forest land was diverted. Then in 2012, the Ministry of Tribal Affairs, which is the nodal ministry to implement the Forest Rights Act, so it's been entrusted with that duty, it came out with a set of guidelines of how to ensure that forest rights are settled. And this was similarly, it laid down how free, prior and informed consent should be obtained. Then in 2013, the Niyamgiri judgment came into the picture, and the Niyamgiri judgment upheld both the 2009 and the 2012 guidelines, and it basically crystallized these two procedures that were laid down by the ministries by way of circulars and guidelines into hard law. So, but even before the Niyamgiri judgment had come into the picture, we can see communication between the Tribal Affairs Ministry and the Environment Ministry talking about how the Forest Rights Act was being diluted and ignored even then, even despite the fact that the Environment Ministry had laid down the circular. So if I could read from the letter actually, so in November 2012, the then Tribal Affairs Minister had written to the then Environment Minister, and the letter actually starts by saying, I wish to share my concern at the continued practice by the Ministry of Environment and Forests advisory and official bodies of ignoring the scheduled tribes and other traditional forest dwellers, the Forest Rights Act, when forest land is being diverted for large projects. And the letter goes on to reiterate the importance of ensuring that forest rights are settled prior to doing that. And it also says that the requirement of forest rights being settled should not be considered just a condition before final clearance is given, but it should be considered at the threshold stage itself before even considering whether such project should be allowed to proceed. So to break down how the forest clearance process works. So once a proposal for forest clearance, so under the Forest Conservation Act, like Arpita said, it is the union government that has been entrusted with the responsibility of giving permission to allow any diversion of forest land to continue. So this takes place in two stages. The first is the in principle consent, where the Environment Ministry in principle, after receiving the proposal from the district collector, considers whether the project should be allowed to go ahead. And then after the fulfillment of certain conditions, like the payment of certain, like the net present value of the forest land has to be paid, there have to be contributions made towards compensatory afforestation. So after doing that, and one of the requirements is that one of the requirements was that the consent of that forest rights settling and the consent of Gram Sabha be taken. Only then could the Environment Ministry give its final approval. And after the final approval, could the state government go ahead and issue the final order of actually diverting the land for non-forest use, so for whatever development project that was taking place. So in 2012, the Tribal Affairs Minister had written to the Environment Minister at the time saying that this is not a condition that needs to be met before final approval is given. This is a requirement that needs to be fulfilled before the union government can even consider the project and decide whether such a project can go ahead. So this was in 2012. Then very interestingly, in 2013, the Environment Ministry issued a circular which said that linear projects would be exempt from the requirement of forest rights settlement and Gram Sabha consent unless already recognized rights of pre-agricultural communities and primitive tribal groups were being affected. So this means that unless FRA rights had already been recognized, only and people who are facing the threat of eviction, only then would the Environment Ministry even consider their consent and their rights before diverting projects for linear projects. Now, linear projects, it gave examples of as roads and pipelines and transmission lines and such. But at the time, there was no definition of linear projects in any law. Neither did the forest conservation rules define it, nor was there any other act which talked about linear projects. So this was in a way something the Environment Ministry had made up, this exemption. After this circular came the Niyamgiri judgment, which upheld both the 2009 and 2012 guidelines, like I said, and it also upheld the centrality of the Gram Sabha and ensuring that these rights are recognized and actually vested with the people, with the intended beneficiaries. It also said, it also, in this case, it also cleared that the consent of the Gram Sabha and the recognition of rights has to be done prior to the giving of final approval by the union government. So now this was in 2013. And after the Niyamgiri judgment, the Tribal Affairs Ministry sent a bunch of communication to the Environment Ministry, and it cited the Niyamgiri judgment. It reiterated that it was the nodal ministry for implementation of the Forest Rights Act, and the FRA did not contain any provision for other ministries to dilute it. Now, the way the Niyamgiri judgment has been interpreted, it doesn't look at the Gram Sabha as someone you just have to ask as just in order to ensure that your projects are proceeding with a humane manner. It actually looks at the Gram Sabha as a regulatory authority at par with the union government in its role of giving forest approval. So they have equal power in determining whether or not a project should go ahead as far as the consent of the forest dwellers is concerned. In 2013 and 2014, they wrote to the MOAF regarding this linear project exemption. Then in 2014, this was the first time the forest conservation rules were amended after the passing of the Forest Rights Act. So here, the responsibility of completing the process of Forest Rights Act settlement and the Gram Sabha was entrusted with the district collector prior to the grant of in-principle approval. So these changes, so over the years, we can see that the stage at which the rights have to be settled, they've just been pushed ahead and ahead. And after some communication, I mean, in the 2017 rules, they were again brought back to before the in-principle consent. But till then, you can see that at one stage, it was required before the in-principle consent. Then there are changes from the Environment Ministry which make it a requirement before the final approval. And now with the 2022 rules, this requirement has been pushed beyond the final approval as well. So in 2014, the amendment rules came into force, and the settlement still had to take place before the granting of in-principle approval. Then in October 2014, the linear projects that I'd mentioned earlier, there was a second amendment to the forest conservation rules that year. And here in the rules itself, there was the exemption for linear projects. And it basically said, again, unless the rights of pre-agricultural or primitive tribal communities were recognized rights were being affected, there was no need for them to ensure that there was consent from the Gram Sabha. Now, this is an issue also because pre-agricultural communities and primitive tribal groups are an even smaller subset of scheduled tribes and other traditional forest dwellers and all the people that the Forest Rights Act takes into consideration. So this was the change that took place in 2014. Then again in 2000. Sorry, there are so many documents. Yeah. So again, in 2014, there was communication again from the Ministry of Tribal Affairs, which said that it does not allow other ministries to relax it. And it actually called this exemption from linear projects a shortcut. And in their exact words, so the letter of 28th October 2014, which again laid down this linear project exemption. This letter takes a shortcut which can derail the projects completely. The FRA is the law of the land. The letter violates the law. And a project which takes a shortcut can be stopped by just one village which has land classified as forest under various laws and court orders. So there's a couple of things you can glean from this, and the first thing is the reasons behind ensuring FRA compliance. Of course, there's the inherent issue of rights, and if someone's living there, their rights cannot be ignored. But there's also the issue of what leads to conflict, and if you're taking projects forward in a way that can lead to people's rights being ignored, you can actually, this would make it prone to litigation. Projects could be stopped. There would be delay in the project itself. And in another letter, the Ministry of Tribal Affairs has also mentioned that such changes, either they could lead to the project being delayed, or they could lead to the state governments evading the law entirely. So because forest dwellers are not a group of people with considerable political power, it's very likely, even with the new change in rules, that any dilution leads to their rights being ignored entirely. So the Land Conflict Watch database of land conflicts, out of all the conflicts we've recorded where people have filed for forest rights claims for community or individual forest rights, out of all those conflicts, in 83% of those conflicts, people still have a demand to retain or protect access to their land. And in 71% of those conflicts, people still have a demand for legal recognition of their land rights. So you can see that just ensuring settlement of their rights and just filing for FRA rights also does not necessarily lead to a situation where there's no conflict or where everything is going in accordance with the law. There's also serious issues in implementation that need to be considered, and that's why any dilution to the forest clearance process when it comes to forest rights just makes the situation that much worse. Because even when you are considering forest rights and even when you are recognizing them, there is an issue of implementation. But if you're pushing it ahead or you're pushing it past the final stage altogether, there's no question that they'll be ignored. So this was in 2014. Then in 2015, the Environment Ministry issued an office memorandum saying that the process of recognition and vesting of FRA rights can take place concurrently along with the granting of in-principle approval, and there shouldn't be any interlinking between the processes. So basically, it looked at different acts such as the Panchayat's Extension to Scheduled Areas Act, or it looked at the 2013 Land Acquisition Act, and all of these acts intersect with the Forest Rights Act in some way or the other. And because there were so many parallel processes happening, it issued a circular saying these can take place concurrently, and there needn't be any requirement for it to be done before or as a condition. Now, the Tribal Affairs Ministry responded to this change with a legal opinion, and it said, yes, it can certainly take place as a parallel process, but it also reiterated that even if it's taking place as a parallel process, at no point should this be pushed beyond the stage 2 clearance, because pushing it beyond the stage 2 clearance would lead to a situation where it's a fait accompli. So basically, it's something that has already been done that can't be reversed. And after 2015, interestingly, in 2017, the forest conservation rules were amended again. And this time, let me just go to the rules. Yeah, this time, the district collector was to complete the process of forest rights vesting and recognition prior to the grant of in-principle approval. And here as well, if you can see, it says obtain the consent of each Gram Sabha, having understood the purposes and details of such diversion wherever required. So here also there is some requirement of free and prior informed consent being included in the rules itself. But later in the next communication we can see is in 2019. Now in 2019, there was another attempt by the Environment Ministry to push the forest rights recognition beyond the second stage. And here I'm just trying to open something. Yeah, here the Environment Ministry circular said that compliance under Forest Rights Act is not required for the consideration of in principle approval. So the Tribal Affairs Ministry had again written back to the Environment Ministry, and they'd said that if this was pushed beyond the in principle stage, this would also lead to a fait accompli, because the project would have made sufficient progress and the tribal people living in the area would be put at a great disadvantage. And that's why the project proponent should produce proof of having initiated FRA clearance at the point at which they go in for stage 1 clearance itself. So now, after this communication in 2019, what we see is the new change now, which says that there will be in principle consent granted, then there will be final approval granted. And then after the final approval is granted, it will be the responsibility of the state government to settle the land, and they shall then issue the final order of forest diversion or de-reservation. Now, there's a separate issue in itself where they're even considering de-reservation of forest land at something that's supposed to be diversion. So the difference between the two is that diversion just allows you to use the forest land as per the terms of the clearance for any non-forest purpose, and any changes that need to be made to that, or if any expansion that needs to be taken, any expansion that is being done, separate permission needs to be taken because the terms of the clearance are very concrete. But what de-reservation does is it removes the status of the land as forest land itself. So once land is being de-reserved, the strict conditions under the Forest Conservation Act no longer apply. So there can be infinite expansion, or the consent of the forest dwellers for any expansion of projects, there's no question of that. So, I mean, that's a separate issue entirely. But I think all of this gives us an idea of what the arguments for and against. And if we're looking at the arguments for relaxing the forest clearance requirements, as the Environment Ministry has done a couple of times in the past, the correspondence from the Tribal Affairs Ministry gives some clue as to that as well. So in multiple letters that the Tribal Affairs Ministry has written, they mention time and again that the Environment Ministry appears to be under the impression, or appears to be proceeding with the assumption, that forest rights and forest rights recognition leads to a delay in forest clearance, and it leads to a delay in projects. So a number of times they've asked for proof that, they've asked for any proof that forest clearance actually leads to delay. They've mentioned that there are actually many other reasons because of which forest rights can be delayed, or because of which forest clearance can be delayed. So I guess that gives an idea of why the Environment Ministry also was pushing for these changes and making these dilutions over the years. But yeah, now this is the point at which it's being diluted now. So you can see over the years how it's been pushed forward from the in principle stage to now where it's beyond the final stage of approval. So yeah, that was, yeah. And I think this final excerpt from a letter to the Environment Minister from the Tribal Affairs Minister also shed some light on this. So he reiterates that 50% quorum and free and prior informed consent of the Gram Sabha is required, but some may argue that this will delay development projects, but this is not correct logic, because it violates the rights of forest dwellers, and that will lead to delays, litigation, and conflict aside from injustice. And this is the language in which they have written to the Environment Ministry over the years. And I'd also, when I was working on my story about this, I was also, I don't have any idea after 2019 what sort of communication has been sent from the Tribal Affairs Ministry with regard to this specific change. But the only information I have is after, like Disha said, after this issue actually gained some mileage, and after people were actually talking about it, the Tribal Affairs Minister took a public stance that all of this is an attempt to distract from the fact that they have appointed the first tribal president. So that's all the information I have right now on where the tribal ministry is coming from. But they have made many attempts over the years to ensure that the Forest Rights Act be considered when forest clearance is considered as well. I think we could open for questions now.
Yes, thank you so much to both of you. That was really informative. And I already have a series of questions from the Instagram chat. And I'm going to start with that. And Dinesh from the team is going to pull up some questions from Instagram. And if anyone on here has any questions, please put it in the chat below. And yes, the recording of the whole webinar is already on the FF India YouTube, so you can go get it there, Ashwin. So feel free to ask any questions in the chat below, and I'll get to it. So this is actually from our Instagram. The first question is how will the new dilutions and the connection between FCA and FRA impact conservation, and is it going to undermine conservation?
I think it'll undermine conservation because it basically makes the forest clearance process much easier. So the faster you can clear a project, the more projects will take place on forest land. So,
and I think just to add to that, the proposed amendments to the FCA also try and do something, which is they create a lot of series of exemptions from the forest clearance process. So you have two arms that are working simultaneously in terms of dilutions. One, as Mukta said, is sort of weakening the forest clearance process itself. And then you have a lot of exemptions where you don't even have to go through the forest clearance process. I'm happy to share more details about that as we go along.
Thank you so much. And the second question is, what is the role of Gram Sabha in the updated conservation rules? I know this was explained in the webinar, but I think it'll just be helpful if they missed that part.
So a quick answer to that is that the 2017 rules very clearly mention the requirement of Gram Sabha consent, but nowhere do the 2022 rules mention that. So as for the Niyamgiri judgment, it would still be required, but I'm not sure what the Environment Ministry is envisioning when it excludes them altogether.
Arpita, do you want to add to that?
No, I think Mukta summarized it quite well. I think the only thing to add to that is to kind of look at it from the perspective of decentralization of decision making and democratization of decision making, and how that's sort of been seen as the cause of delay, as Mukta was saying. But really, that's a question that's at the heart of a lot of these dilutions, and I don't think that's necessarily the route that's worthy of taking. But that's my own opinion.
Thank you. Another question, I think this will be useful for everybody to understand, is how do you see the dilutions being implemented? And is there space for more error and more sidetracking in terms of the ministry not following the law? Sorry, I don't know if that made sense.
I'm not sure about that.
Okay, sorry. I thought you wanted me to repeat. So.
No.
Yeah, could you repeat it? I don't know if I was able to get that, but
I think the question was, how will the dilution impact how the law is implemented, and will it make the implementation also more lax?
that's like speculative legal fiction. We don't know.
Yeah. When the law itself has been diluted, then does it really matter if the implementation is better or worse when the law itself is making it so easy?
Yeah, exactly.
I think, sorry, from what I understood from the question, I think the person meant, can it get any worse than this when it comes to actually implementing it?
I don't know, Mukta, you want to start? And then I have like, I mean, two potential scenarios, but this is, like I said, it's speculative legal fiction.
Yeah. I mean, either way, I don't see why not.
Yeah. I mean, I think perhaps one way to think about this is the dilutions are trying to make decision making quicker and faster, right? And in doing so, there's this idea that the compliance burden on corporations is going to be light. So they're able to quickly go through these bureaucratic processes. But then the question is that it's not like forest dwelling communities, it's going to get harder on them. So there's going to be a lot more litigation, as Mukta was pointing out, and a lot more conflicts on the ground. So in terms of one of the scenarios that I fear for is, I don't know if they're going to weaponize criminal law more against environmental defenders. And so that situation is something that I want to keep an eye on, and I think everybody should. Because that again protest is seen as another route for delay, and then the law doesn't provide you an avenue to articulate your dissent. So there's going to be perhaps more violence on the ground, but I really pray that's not the case, and so I'll just stop there.
Thank you so much. And I think a follow-up question to that is, sorry, my screen is glitching and it's frozen. Sorry, just give me a minute. Yeah, sorry, it's back. Another thing that is like a follow-up to this question is there anything that can be done legally to challenge not just the dilutions? Because in the case of the EIA, we saw that even though the dilutions were then the amendments were put on hold, they still started to pass some of the amendments to individual notices. So is there something people can do individually, as well as during the process, before the time period for the comments closes, and after as well?
Sorry, was the question whether these new rules can be challenged legally?
Yeah, before they close the time period for receiving objections, and what can people do after legally as well?
I think, if I'm not mistaken, I think these rules were never put out for consultation to begin with.
But the FCA still is.
Yeah. I mean, I think Mukta is probably more well-versed in terms of, the legalese around this, but one way one can sort of legally be part of the process is obviously actively providing comments within that window. Granted that these windows are really short, so having quick research accessible for everyone to be able to provide nuanced comments is useful. So that's sort of one way of thinking about it. After the rules or any kind of, so there's another thing to be mindful of the routes being taken in terms of how these dilutions are made possible. So like as Mukta said, the rules have never been put up for consultation, and very often that comes within the realm of what we call delegated legislation. And very often the executive has power of rulemaking in that sense through notification. So a lot of the dilutions happen at that level. And there isn't an obligation for them to consult. Whereas if it's a law that's being changed, we have a policy which requires public consultation. It's only a policy, so it's again optional. So assuming you provide comments, very often the eventual outcome that's shared, you don't know what happens between you providing the comments. It's kind of like a black hole, and then it goes in, and then you have the eventual legal outcome. One way to do it is to go to court. One of the cases that is interesting is when the EIU is being diluted in a way that it was supporting real estate companies. There was a case where the National Green Tribunal actually ruled against that dilution on the basis of what they call the principle of non-regression, which is, I think, one of the most amazing principles of environmental law, where it says that you cannot go to a lower legal standard. You can only go to a harder legal standard, right? So I think that the dilutions are completely in violation of the principle of non-regression. So that's another way to think about it legally and argue through it. But yeah, courts are, judicial review is the last resort option, apart from protest and other political ways of handling it.
Thank you so much, Arpita. I think that is very helpful. This is an interesting question. So we do have very young people tuning in, and one of the question is, how would you explain both of these laws to a 5-year-old? Yeah.
Do you want to take a shot, Mukta?
Like literally a 5-year-old, or could 10-year-old do?
I think 10-year-old is
okay. So forest rights. So there are people who've traditionally lived in forests. Their rights over that forest land are protected by the Forest Rights Act. But there's also resources in forests. There's land which people want to use to develop for other commercial or private projects. Because both these groups of people have interest over the forest land, and there's some sort of conflict between them. And with regard to the Forest Conservation Act, before any developer actually gets to use that land for whatever commercial activities they want to do on it, they first have to take permission from the government in order to ensure that all of their activities and that permission is granted in accordance with the law. So this also includes ensuring that the people who already live on that forest land, their rights are not negatively affected, and that they also have some say in how that land is being used. So the forest clearance process also ensures that these people are consulted and that they agree before the government gives permission. But here the government has said that they won't bother to ask those people before they give their permission, and they'll only it'll be another government's responsibility to check if they're okay with it after the government has already given its permission. So that's the issue here.
Arpita, do you also want to?
No, I think Mukta did a good job. I was thinking of like a fun way to describe it, but I think she did a brilliant job. So I'm not gonna add more confusion in the mind of a 5-year-old or 10-year-old.
Maybe with a Clinton example.
Yeah, I was thinking of a Clinton example, actually. I was thinking more in terms of like the Forest Conservation Act basically being this idea that the state has complete control. So the state is guarding the forest. So sort of thinking of it as sort of, I don't know, Captain Haddock and Tintin sort of guarding the space. But doing it in a way that they don't realize that there are people who are already doing that, and there are communities who've been living there, and they think it's actually, I mean, now look at me going into the IFA, so which is why I think I should stop. And I'll stop at the point where I think what the FRA does is it recognizes as Mukta said, that the communities have an important role to play, and that they have already been playing that role. So it's not that it's a sudden realization. So it's kind of a law that is more backward looking and trying to correct some of those really giant mistakes. There are limitations with the Forest Rights Act too, but that's definitely not something to communicate to at any rate. But I'll stop there.
Thank you so much. I think that's really helpful. Another question by Shubha in the chat is that do we have examples of consent being acquired in an initiation stage of a project with other laws, non-forest context? And is there any legal backing for this?
Sorry, could you repeat that? I didn't understand.
Yeah. So Shubha has asked if there are any examples of consent being acquired in the initiation stage of a project with other laws or non-forest context, and is there any legal backing for this?
The Land Acquisition Act requires consent from the Gram Sabha, but I can't remember at which stage. So I think after the notice of acquisition is issued, the relevant Gram Sabha and the people affected have the right to object to it.
Yeah, absolutely. And I think, Mukta, if you want to continue, I don't want to.
No, go on.
I think what's interesting about this question is where does the consent framework, the consent requirement fit within a giant framework of clearance processes, if I'm interpreting that right? And I think ideally the consent process should be one of the, as Mukta earlier described, as like sort of a threshold requirement. So initially to see where that's actually happened. And an example that comes to mind is mostly cases where that does not happen. So you have a situation where a decision gets made by the government to deforest or acquire the forest land. And then it's kind of like communities are like, but the consent was not taken properly. It's not, abiding by the standards through which it's been taken. So then it's sort of having to reconsider those decisions. And not all of those decisions get reconsidered. But as Mukta also pointed out, there is the consent process within the Land Acquisition Act if it's a non-forest land. So that's where it will apply. And in terms of other laws, like I said, like forest areas attract a multitude of laws. And so it's got its own sort of legal universe. There's the FCA and FRA are just parts of it. There is the IFA, there's the Wildlife Protection Act. And if it's a scheduled area, you also have the Panchayat Extension of Scheduled Areas Act. And the issue has always been which law gets prioritized and how does that eventually feed into the decision? Because the Environmental Protection Act also applies. So the EIA process also applies. So it's kind of, in a way, one way to think about it is there are multiple ways in which the project can be challenged, right? There are different ways in which that can happen. Or another way to think of it is that tension between where the state continues to hold decision-making powers and decentralized avenues get disregarded or considered. And that's how most of these land conflicts and environmental conflicts play out.
Right. Yeah, thank you. That's so interesting. I just wanted to ask because I know the EIA also has a public consultation and but some of the what activists keep recommending as changes is that it should be consent should be acquired at an earlier stage, and so I was wondering whether there were any laws where consent was actually mandated at an earlier time frame, as you said. So yeah, I will look into the act you mentioned. So thank you.
Another question is, what's different about the Hasdeo forest and the relevance of the Gram Sabhas here? And also, what is the situation now?
Would you like to answer that, Arpita?
So I can take a part of it. I don't know what's happening on the ground now. Sadly, most of my updates are coming from Twitter, so I don't know whether that's a good resource or not. That's up for grabs. But in terms of for me, what's interesting about the Hasdeo case is it's actually a coal mine, and in coal-bearing areas, as the law categorizes it, there's a different acquisition process, right? So the Coal Bearing Areas Act, in some ways, has its own procedural set of things that it does, which is much faster. Because the idea there is that coal is sort of a national resource. We need to be able to access it quickly to be able to provide electricity. So there's a certain discourse of absolute state sovereignty in these areas. And if you read the Coal Bearing Areas Act, you'll see that, where the notice period is short, the window to provide objections is short. And there's also an assumption that once the land, so I can't speak to the Hasdeo case, but I did fieldwork in Sundargarh, where the Mahanadi coal plant is the coal mines are expanding. And over there, it was assumed that once the land is acquired under the Coal Bearing Areas Act, then there's no requirement for them to obtain consent. It's assumed that the land is now state land. So there was a situation there where they had actually acquired the land way back in 1987. And the Forest Rights Act is applicable only from 2008 onwards. So they said, we don't need to, we've already acquired the land. So I think the tension in coal-bearing areas is a little different. And I think in the Hasdeo case, and I just heard that the court is going to hear this case, where they are protesting that the Gram Sabha consent was not adequately taken. And I think it's an important case because we need to reassert that the Gram Sabha consent provision applies even in coal-bearing areas. Because there's a lot of legal grayness around that interpretation.
I think in Hasdeo, the communities are alleging that their consent was forged, which is a major concern that that people have raised about pushing the consent requirement to beyond stage 2 as well, because once the project has already been approved, there'll be a rush to get the consent. So it's prone to modification or destruction of existing claims of FRA claims and evidence in support of it. Not people, actually, the Tribal Affairs Ministry has said this.
Yeah, I think those are all the questions we've gotten so far. If I have missed any, please feel free to drop it in the chat. Otherwise, is there anything both of you would like to add before we close?
I just wanted to thank Fridays for Future and Yugma for organizing this. And thank you, Arpita, for breaking down the law.
And one question before that, since Hasdeo thing is inside this Coal Bearing Act, does that make Gram Sabha consent not necessary in Hasdeo thing?
I think the jurisprudence around that is unsettled. I think it's been in some cases, the bureaucracy has assumed that. In some cases, Coal India itself has passed bylaws within their acquisition process where they have said consent doesn't apply because it's a compulsory acquisition. So there's a lot of confusion around it. And since this case is going to court, we'll see what happens. But there are examples where the court has said that it does apply. So it's kind of unsettled.
I just wanted to point out something to look out for. So the forms for the forms that have to be submitted for the clearance process, in all earlier sets of rules, these forms were part of the rules itself. But now in the new rules, it's said that the forms will be notified by the Environment Ministry at a later stage. So they haven't been tabled before the legislature, so they could also be something to look out for. That was unrelated to your question, but I just I just thought of it.
No, like, yeah, I could understand like its relevance to it. Yeah, like even if we win the case in court on this Kastiyuka Grama Sabha thing, even if this new forest conservation rules comes into existence, then that won't be helpful for Kastiyuka thing. So this forest conservation rules is anyways in that to the protest that is going on in Kastiyuka, right? Yeah, that's what I do.
I just wanted to say thank you as well to Disha, Fridays for Future, and Yukma and Mukta too. I felt like I was taking notes as you were speaking. So thank you so much for your legal research.
Thank you.
Thank you so much both of you, Arpita and Mukta, for joining us. I think that was super insightful, and we really enjoyed the presentation with Tintin and Hammock joining us. I think it was really helpful to break down what would otherwise be very hard for a lot of us to understand. And this will really help us plan our campaigns better and also understand what we can do legally before and after. So thank you so much for joining us. And this is also just to announce that this is not the end of our series. We'll be having 3 more sessions with other speakers on the different laws that are being diluted, like the Environment Protection Act of 1986, the Water and Air Act, and the Public Liability Insurance Act. And we'll keep everyone posted here on when they are. So, but thank you so much for joining today, and thank you for the great insights that you have provided.
Thanks, Disha. Bye, everyone.